Hello, everyone. This is Nina Olson. I'm the Executive Director for the Center for Taxpayer Rights. And this is the today's webinar is representing domestic violence survivors in IRS disputes. And this is a program put on by the American Bar Association Tax Section in conjunction with the Center for Taxpayer Rights and our LITC Support Center project. It is the part one of this series. It's a two-part series. And the second part, so you can mark your calendar, is going to be on April 21st, I believe. And that will be involving representing domestic violence survivors in innocent spouse disputes. Today, we're going to talk about family benefit type disputes, the child tax credit, the EITC, etc. Before we go to the actual webinar and my introduction of the panelists, I want to do some housekeeping. First of all, if you are seeking continuing legal education, CLE credit, you must attend the entire program. Partial credit is not available. And to get that, credit, during the program, there are going to be a number of polling questions that will appear on the screen, and you need to respond to each of the polling questions to confirm your participation in the program. And then 48 hours after the end of today's program, you will receive an email link containing a link to your CLE affidavit and information on how to receive your certificate. So you need to complete the CLE affidavit, providing your bar information as requested. And then once the completed form is submitted, your certificate will be emailed to you. So don't forget to respond to the polling questions. So let me introduce our speakers. Next slide, please. We are really lucky today to have a very experienced group of folks. Terry Morris, who is the Christine A. Brunswick Public Interest Fellow and she's at the Community Tax Law Project in Richmond, Virginia. We have Kim Pentico, who is the Director of Economic Justice at the National Network to End Domestic Violence in Washington, D.C. Nancy Rossner, who is a senior attorney at the Community Tax Law Project, excuse me, and then moi, Nina Olson at the Center for Taxpayer Rights. So now let's go on to the next slide. Just to set up this issue, and also just for you all on the call, we are going to use the chat for questions and answers and if comments. So don't bother to go to the Q&A. We want to make it really easy to do the chat. I'll be monitoring the chat during the program if there are things you want to say or questions that come up, and if we can incorporate them as we're going through the presentation, that's great. If not, we will definitely reserve time at the end for people to talk, ask questions, share your thoughts. How this program is going to go is that we're going to set up the issue of domestic violence and the consequences of domestic violence as it relates to taxes. And one aspect of domestic abuse, domestic violence, is financial abuse. We will then go through some of the current law, the eligibility requirements for tax benefits that relate to family, your filing status, children, EITC, the Earned Income Tax Credit, etc. And then we will really take the time of having a case study. It's a very complex case study that moves through, and then there's a tax case study, and at that point we'll be having a discussion about how to actually represent the taxpayer. What are your options, and where does domestic, being a survivor of domestic violence and some of the consequences of that show up in your representation, how it might have some consequences for your actual representation of the client. Now, someone asked if there was a handout. There will be a handout available that has been put up in the chat so that you can see the slides. And then there are links in the slides to get additional materials. So again, just to set up, in the context of domestic violence, one aspect is financial abuse, and we will see this in various ways. First of all, you may have the abuser having filed an invalid return claiming the survivor as the spouse on that return, even though the spouse has not consented to a jointly filed return. You may also just have pure fraudulent returns using the survivor's Social Security number. You can have improperly claimed children on the abuser's tax return, which prevents the survivor, who is the person is the eligible taxpayer with respect to those children, not being able to easily claim those children. You can have identity theft, including employment-related identity theft. You can see a formation of a business using a survivor's information. And you can then, once it's down the line and even under valid jointly filed returns, there may be income tax balances that the survivor is unaware of that have been unpaid. That will be the subject of our part 2 in our series here on representing survivors of domestic violence. So next slide. And now I think Kim is going to take this over.
Fantastic. Thanks so much, Nina. Thanks so much for having me and allowing me to join today's session. I look forward to it and look forward to continued work together. So I'm here to sort of frame why we even are talking about this issue and why what the impact of finances in particular has in survivors' lives. So statistically speaking, we know about 1/3 of all women will experience some form of domestic violence or IPV, interpersonal violence, in their adult lives. But we know a much higher percentage, closer to 60% of women who are living in poverty experience it. So it's a much higher prevalence for survivors, for women who are living in poverty, of experiencing domestic violence. And studies showing anywhere from 8 to 33% report current or recent violence, and then also a much higher prevalence of childhood physical and sexual violence also for those who are living in poverty. So let's unpack that for just a second. It's important to understand that having limited financial resources is a big risk factor to domestic violence. So it just makes sense. Fewer resources equals fewer good choices for getting and or staying safe. I often use the example, of myself. I consider myself pretty middle income, and as we know, family income often follows familial lines. So I also have a mother who's pretty middle income. So if my home becomes unsafe to me tonight, I can get into a gassed up car, I can drive up across town, I can stay in a pretty safe hotel, or I can go live with my mother if I need to. I could even buy a plane ticket if I needed to and flee several states away. Versus if if I'm living in poverty, that fleeing is going to look very different. It may mean that I stay in my car overnight. It may mean that I stay in a hotel that's not particularly safe. Or I may double up with my mother, who also probably statistically speaking is also of lower socioeconomic status, or doubling up with friends and staying on a couch. So that negotiation looks very different than when my partner calls and apologizes and begs me to come home, than if I am, if worrying about how I'm going to pay for a tank of gas to get home, that negotiation looks different. It doesn't mean that the abuse is not real, or that my worries and concerns about the physical violence are not real. It simply means that is one less thing I have to worry about when I am negotiating my safety with my partner. And we also know, due to that increased vulnerability that things like poverty cause, it increases my vulnerability to my partner's violence and future violence as well. And we also know, statistically speaking, that the abuse is likely to last longer and result in more severe injuries. However, it's super important that we understand that leading does not, it does not mean that those living in poverty are more violent. So I don't want anybody to hear that. And it does not mean that those living with plenty of financial resources are not experiencing or at risk for experiencing violence. It simply means that their access to gaining and maintaining safety may look different when you have financial resources to do so. Now, certainly, I'm sure we've all worked with survivors who have plenty of financial resources but don't have access to them, or can access them and still are in physical danger and violence. But we do know that poverty is itself its own risk factor to current or future violence. So let's talk about what we mean when I talk about financial abuse, because I think it's important to level set. I'm sure you've all probably heard of power and control wheel. If you've ever worked with a domestic violence advocate, we love a wheel. And this is the one where it all kind of started, was this power and control wheel. And how we talk about domestic violence, we often say it's an advocate's term of domestic violence. There's the legal term of domestic violence, which is, the legal term is domestic battery or assault. But there's domestic violence, which is an advocate's definition. And at that center of that is power and control. And it is one person's desire to gain or maintain power and control in that relationship. And they use all of these tactics like male privilege, coercion, threats, intimidation, isolation, use of kids, and economic abuse to keep that power and control within that relationship. And so when those sorts of tactics fail, like economic abuse or coercion and threats, then is when we see physical or sexual violence be employed. So many of the tactics within those 8 spokes are often not illegal. Many of them are not illegal. It is not illegal to take a credit card if we're married out of my purse that we're married and to go charge on it. And it is not illegal to move to a place and take the only car available while you go to work. But that is incredibly isolating if I'm also being a victim of domestic violence. It's actually not even illegal to call me names. It's illegal to threaten me, but it's not illegal to call me names. So much of these tactics are not even illegal, but it is often then when those tactics start to fail or are threatened is when we see physical and sexual violence. Like all of these tactics, they begin subtly and progress over time. And so they are very subtle in how it happens. And so it's often also hard to see it because it happens so subtly. So an advocate's definition of domestic violence is a pattern of abusive behavior used to gain and maintain power and control within that relationship. And it is what we often hear from survivors is traps them in that relationship, particularly the financial abuse itself. If you think about it, 99% of all survivors report some form of financial abuse occurring. It is incredibly effective. And that many of these tactics that we see abusers use can actually plummet a survivor into poverty. The example I got of myself, if I am, over and over again tapping into a credit card or using savings to get a hotel for the night or to flee the state, that I may actually move from middle income to lower income because I've actually used my resources to maintain safety. I may not be able to go to my mother's anymore because she's tired of dealing with it. And so those actions of my partner actually can actually result in somebody living in poverty. And we also know that often use of economics and finances is a way to control that partner. So things like harassing them at the workplace can be really effective, calling over and over again, showing up at their workplace, threatening them can be really effective. So then they lose their employment. They lose that one out they had, that one source of their own income. They actually will lose it because of the domestic violence and one of the things that the abuser is using. Identity theft, ruining credit. We see this often in survivors of domestic violence. They will take out lines of credit they never knew existed. They will use existing lines of credit and will steal their identity, which is also terribly, terribly hard to prove and to have any law enforcement interaction with. Things like causing an eviction is incredibly effective. Putting holes in walls or being so loud that the neighbors call and law enforcement comes out to the home and the landlord doesn't want to deal with it, so they evict them. Certainly there's protections in certain kind of housing. Public housing does have some domestic violence protections, but not private landlords. And so it can be really effective. So now that person's homeless on top of everything else. Other ways we see it is forcing illegal activities. So forcing illegal activities like, maybe he is less violent if she scores dope for him for the night. So then she gets arrested, or she is writing bad checks or has done something else illegal. Then she is charged with that, which also then decreases her chances for future jobs or housing as well, because you can't get those things if you have a felony or conviction of some sort. And the other place we see it a lot is sabotaging success at education or even for work or future work. So we hear survivors say, he blackened my eyes because he knew I wouldn't go to work or go to the interview if I had a black eye, or he kept me up all night so I couldn't go to the interview, or he was my childcare for the day and drank all night and knew I wouldn't leave the kids home alone with him when he's drinking. So doing things really subtly to sabotage her ability to have her own freedom or have access to her own source of income. So the other thing I want to make sure that we're also really clear on is that leaving an abusive relationship can leave a survivor in often an impossible, not only financial situation, but also a physical situation. Statistically speaking, we know that survivors' lethality, and that's her risk of dying at her abuser's hand, increases by 7 times when she makes an act of independence, like filing for a protection order, like reaching out to an attorney or disclosing to an advocate. But her risk of dying increases exponentially when she discloses or reaches out for that sort of assistance. So it's important to understand that leaving does not always equal safety, which I think can be really counterintuitive, right? If your friend or your sister or your loved one comes to you and says, my partner hurts me, our instinct is to say leave. In reality, because we know what's at the center of domestic violence is power and control, that leaving challenges that power and control. And that is when often we see the physical and sexual violence amped up. And so it's super important that, that leaving be done really thoughtfully and as part of a plan, and is not something that typically is done in a one-time event and it's over, that it takes multiple times, it takes planning. And we're just not well suited as a society to embrace her and catch her if and when she needs to leave. And so I don't know if you're aware in your communities, I would encourage you to reach out to your public housing authority and find out what the wait list is for any sort of housing or housing assistance. It's often 2-3 years. Many housing lists are closed because there's just no availability. So there's just not a lot of great options when survivors are able to make the decision to leave. So for many survivors, it's often an impossible choice. Stay and risk harm and maybe harming my kids, leave and also potentially risk harm, plus I have less income and all of those kinds of things. So it is a really challenging situation that many survivors are in the middle of. So one of the things I also just want to point out, particularly to this group, is I think we have really shifted, and I see it a little less now, but mediation. And I want to just caution folks when it comes to mediation. You saw the statistics, 1 in 3 women will experience some form of IPV in their lifetime, right? So that's important to remember that 1 in 3 folks you're referring potentially to mediation or that are referred to mediation may not be in a safe place to do that. Mediation, as you know, requires both parties or partners work together to reach a settlement. And it also assumes equity in voice and safety. And so it is often not a good or safe option for victims of domestic violence. If we hear from survivors, if I am not honest, the settlement will not be fair. And if I am honest, I'm going to pay for it later, physically. And so it is often incredibly impossible for survivors to navigate that. Some things to think about. And I don't know if y'all have been to the doctor recently, and I know it's really amped up in my area, but I'm sure your doctor or some of you has at some point has screened you for domestic violence. I don't know if you've experienced this, but I would encourage you to start getting comfortable with having conversations about just saying, domestic violence is common. This is something we ask all people. We want to make sure everybody is safe as possible. But to create that environment where that's a normalized conversation in your practice or whatever you do. So I would encourage you to standardize meeting with folks separately at some point, even if it's just for a minute or two. And then, maybe a thing you could say is, we want to make sure this process is both fair and safe for you. If at any time you feel like you're unable to provide candid information, please feel free to contact me or the office anytime following today. Just to set the stage, the goal is not necessarily disclosure, but it is to let them know that you are a safe place to have that conversation if and when they ever want to do that. So, something to think about. I would also encourage you to provide maybe a flyer on the inside of all your bathroom stalls that provides where to go for assistance in your community. Hopefully you know who your local domestic violence provider is, but that this is a great place for survivors to get information in a private, safe way. And you could even say that as part of your screening when you ask those questions and say, hey, if you don't feel comfortable talking to me, there's information on the bathroom, inside of the bathroom door if you want to grab it on your way out. But so that would be something to consider, just to provide that safe place to have that conversation. And lastly, I'm sure you're all ready for me to wrap it up. I always end with a picture of my kiddos. These are my kids when they were 5 and 3. This is McKenna and Maddox. This is when they thought I was brilliant and had all the information. This is them when I dropped my daughter off at college. This is McKenna and Maddox at 18 and 16. I always put a picture of them up because I always want to remind myself that doing this work does not guarantee their safety, and that I'm a part of creating a safety net for them if and when they should ever need it. So it is my reminder to you that everybody you work with is somebody else's McKenna and somebody else's Maddox. So on behalf of McKenna and Maddox, thanks for being there. Thanks for doing the work that you're doing. Thanks for catching them and being part of my safety net if we should ever need it. So thanks.
So Kim, that's just really wonderful, and your children are beautiful. We did have a comment in the chat about, do you have statistics for male victims and survivors? How many men and boys experience this? Are there different approaches recommended for helping them?
Yeah. So I appreciate the question. So it's somewhere between 1 in 6 or 1 in 9 for victims of intimate partner violence. So we know certainly it happens within same-sex partnerships too. I want to be really careful. Certainly we know it can happen. Certainly we know that men can be victims of domestic violence. I do think that we don't have to suspend some things like sort of not common sense, because that sounds like I'm talking down. I'm not trying to at all. So let me back up for just a second. We know women use violence. I'll put that all out. We know women use violence. Not all violence is domestic violence, right? So let me give you an example. So if I'm partnered with a male and he comes home out of the blue, or my partner comes home out of the blue and I say, take out that trash, and I smack him across the face out of the blue, right? Illegal, unacceptable. He should call law enforcement. I should be held accountable. I should be charged, all of those things. I did not commit an advocate's definition of domestic violence. I committed the legal definition of domestic battery, right? Because it was not part of a pattern. I would likely not be able to put him in a place of fear, but the behavior was unacceptable, right? And so I think that we have to be really careful about, we certainly accept that women do use illegal violence, unacceptable, but that may not always rise to the advocate definition. Doesn't mean we don't hold everybody accountable to their violent behavior. So I'm not saying that at all.
Mm-hmm.
Certainly we do know that in some cases women can impose that sort of fear on their male partners, put them in a place where they don't feel safe and are cowering and all of that. It is a much smaller statistic. And we do also know that it occurs within same-sex partnerships, both for men and women as well.
Okay, thank you. So now we're going to go to Nancy. I know there's been some really great questions that are going specifically to the representation angle, and I'm noting them, and I will share. We'll talk about them at the end, or incorporate them into our case study. So now we're just going to go on to sort of forming the legal basis of the statutory provisions. So Nancy,
do you want me to stop sharing on my end so that DeMarco?
Yes.
There we go. Perfect. Thanks.
Great, thank you. So here we're outlining some special considerations for survivors of domestic violence, specifically with tax disputes. And I think Kim laid a really important background so that we can understand where the survivor is coming from a little bit, and how and why they may react to certain situations in a certain way. So here we're outlining that domestic violence survivors have fewer safe options available to them to resolve the situation. We were thinking about that, I think, way when the stimulus payments started going out, and we were already concerned in the community, how are we going to help survivors? We saw the opportunity for EIP to be used strategically to hurt survivors, and that a lot of times with the IRS, if they feel like they've paid out according to law, under the law, they view it as a civil dispute and something that needs to be handled in civil court, and not something that needs to be handled with the IRS. And really our complaint with that is that, domestic violence survivors are a very vulnerable population, and they just don't have the same options as someone who's not in that situation. So it's just really important to remember that safety is always going to be paramount when considering what their options are moving forward. So it can be dangerous for a survivor to communicate with an abuser, and not always, but I think that's something to discuss with your client as you're trying to assist them. And the abuser can use the EIP and maybe even the advanced child tax credit to manipulate the survivor. So I think we saw that a lot too with the stimulus payments going out, especially because they were being issued based on prior filed tax returns, that the EIP was oftentimes going into the hands of the abuser and denying the survivor access to the EIP. And as we heard from Kim, economics plays a really huge role for survivors when they're trying to establish safety, if they're considering leaving their abuser. You know, something like the EIP, $1,400, that could be a security deposit on an apartment, or that could be a couple plane tickets for them and their children. So the EIP really became almost a tool, you know, again, within that power and control that the abuser is exerting on the survivor. Something always to consider too when you're working with a survivor is if the abuser is potentially going to retaliate. So, you know, I know Nina's going to have another panel on innocent spouse, but that's always something that we discuss with our survivors if we're assisting in a tax matter, is that if it is something that can come back, you know, and the abuser may be informed that the survivor is stepping aside and asserting independence, you know, is there a potential for retaliation? Because if so, maybe that's not going to be a good option, and maybe other options need to be considered. So even with things like the EIP, if the survivor is challenging it and maybe they're able to prove they were supposed to get the EIP, or maybe with the child tax credit, you know, if the IRS makes adjustments to the returns, it is possible in certain situations that the abuser or the, you know, joint filer that they were previously with could be alerted to the fact that the survivor is trying to assert, you know, maybe there was an invalid joint return filed, or that the tax credit was claimed, you know, due to fraud. You know, those are just a couple of examples. And then lastly, here we have that if they're living in a shelter, the survivor may be vulnerable to information and identity theft. So a lot of times with our survivors, we recommend things like, you know, requesting their one free credit report a year. There's a website, annualcreditreport.com. We're not affiliated or anything, but they do allow one free credit report from the 3 major credit reporting agencies. That's one tool that they can use to try to see if there's been anything, you know, popping up using their information that maybe they weren't aware of. Because a lot of times when we see the financial abuse, they may have been restricted. They may not have had access to any of the finances. They may not have had access to bank accounts. It's possible that if they were employed, that they were required to hand over their paycheck and may not have, you know, even gotten to deposit the money and use it. A lot of times maybe they're given a small, you know, weekly allowance to buy groceries. We see that pretty often. So it's just important to keep these things in mind. And if you can, you know, remind them that there are these little tools, like maybe getting your credit report, you know, a free credit report where you can research your account. Or we also advise them on trying to get an online services account with the IRS so they can check their transcripts and see if there's anything popping up there that maybe they didn't anticipate. So we can move on to the next slide here. So this is a great slide. I'm not sure that everyone's aware of this. I think this came around, I want to say several years ago, due to Susan Morgenstern, I think was a primary proponent of the victim of domestic violence indicator. She was a previous LITC clinician who's now with TAS. And the victim of domestic violence indicator is an indicator that you can request that the IRS place on a taxpayer's account to alert the IRS representative that domestic violence could be present in their lives. That's both with innocent spouse relief, but also through accounts management. So it's not restricted to taxpayers that are requesting relief from joint and several liability through innocent spouse claims, but also you can request that with accounts management. It's just one more way to alert the IRS that there could be some things going on in the account that they need to keep their eye on. You know, that could be, you know, potential identity theft down the road, and the victim of domestic violence indicator may put them on notice that, you know, number one, they have to be more sensitive to the taxpayer, to their location information, and also their personal identifying information. And then number two, I think down the road, if there are claims that need to be made, claims about fraud or identity theft, it's alerting them to that fact. Next slide, please. So here we're going to talk a little bit about the recovery rebate credit. Those were the economic impact payments or stimulus payments that went out during 2020 or 2021, that if they weren't received, could be claimed as a credit on the tax return for 2020 and or 2021, known as the recovery rebate credit. We see these in situations where, and Terry can probably speak on this, she's been working with some clients very recently, where the EIP was going to the abuser and the survivor did not have access to it. And you can see that in a wide variety of situations. It might be that they had some sort of agreement that they would file jointly, and then the abuser was supposed to give them their portion of the refund from the stimulus. Or it could be that a return was filed without their knowledge, without their permission, without their consent, and therefore it was fraudulent. And it's still depriving the survivor of their stimulus payment, which was the recovery rebate credit on the return. So what we would advise in this situation is to go ahead and file the return and claim any EIP as the recovery rebate credit that they did not have access to. So in the IRS system, it may look like it was paid out to the taxpayer, but if the taxpayer did not have access to it, that is our argument. The taxpayer did not have access to it, and the IRS did not establish any sort of mechanism by which taxpayers could alert the IRS to some sort of fraud or that the EIP was going to the wrong person. So this is really the first step, and probably what's going to be a pretty long process of challenging the way the EIP went out or to whom the EIP went, especially if it wasn't, the taxpayer that you're assisting. Another great point here is establishing an invalid joint election. So there's a link here to a blog post by the National Taxpayer Advocate that outlines what a taxpayer can do if they believe that a joint return was filed, but that the joint return was invalid. So that could mean that, number one, the survivor was not married, but a joint return was filed with their name. Or number two, it was filed due to fraud. So perhaps their signature was forged, or they did not give consent, but the return was filed anyway without their consent. And in a third way would be if the taxpayer did go ahead and agree to the joint filing, but did so under duress. And so the duress would basically invalidate that joint filing because they felt like they had no other option. They were concerned that they were at risk of physical violence or other violence and felt that they had to go ahead and agree to the joint return or even sign the tax return. So this blog post outlines, how to challenge the joint filing. And again, you're probably going to be dealing with, math error notices or other notices from the IRS, saying this conflicts with the information that we have on file. And really, you just need to view that as step one to alerting the IRS that there was a problem and asserting your client's claims to get that stimulus payment that can really mean a huge difference in their lives. All right, next slide, please. So here we're going to talk a little bit about the child tax credit. First, we have just real briefly the eligibility criteria for the child tax credit. Now, this is not a new credit, but the way that it was being distributed in 2021 in advance is new, based on the American Rescue Plan Act. So, the child has to meet the relationship test outlined in 1, the age test outlined in 2, the support test outlined in 3, and the residency test outlined in 4, as well as the remaining 3 criteria. And these are things that you probably will see a lot when it comes to eligibility for the dependency exemption and also eligibility for credits like the earned income tax credit. They may vary a little bit from here to there. Things like, the age limit, for example, for the EITC is a bit higher. But a lot of them do revolve around relationship and residency So when you're thinking about that, I want you to think about already, okay, what documents may we need to prove these different items? Because if you know that you're going to be in a dispute with your taxpayer where you're trying to prove eligibility for the credit, most likely the IRS is going to need to see documentation supporting each of these criteria. So things like birth certificates, lease agreements, utility bills, there's a lot of different documentation that can be provided. And I encourage you to think outside the box, because oftentimes when we're working with survivors, they may not have access to a lot of documentation. They may not retain records. They may be very transient. Some of them may leave in the middle of the night with nothing but the clothes on their back. So I think it's our job as zealous advocates to try to think of ways that we can assist them in gathering documentation and going back and trying to recreate their record. Next slide, please. So this slide outlines the special rules for tax year 2021, which did change the child tax credit to the advanced child tax credit in a lot of great ways. It allowed for an advance payment of half of the credit. Those advance payments were paid out monthly beginning in July and going through December. The credit amount was increased from $2,000 to $3,600 for children under the age of 6 and to $3,000 for children under 18. And the credit was expanded to include 17-year-olds. So previously 17-year-olds were not eligible for this credit to be claimed as qualifying children for this credit. Then the IRS used the most recently filed return on file, the 2019 or 2020 tax return, to automatically enroll taxpayers to receive this credit. And they also created an online portal for taxpayers to update certain information. However, they did not meet all of the requirements that were written out in the American Rescue Plan Act. They did fail to allow taxpayers to update a change in marital status and qualifying children. So for example, if a child was born in the year 2021, taxpayers were unable to update their records to show that they had an additional child and would qualify for a higher credit. So these changes were really helpful, I think, for taxpayers that just have what we would say like a normal white picket fence situation where it's two parents, children, all living in the same household. They're not divorced, they're not separated. But for a lot of people that, are living in situations that are not like that, they could be separated, they could have agreed to alternate children year after year. They could be getting divorced. There's a lot of untraditional situations that this presented some issues. So for example, using a prior filed return to automatically enroll taxpayers for the following year for the credit posed issues, because let's take a survivor, for example, who is still with their spouse. They filed a 2019 or 2020 return jointly, but then they separated, and then they were automatically enrolled for the credit. It's very possible that the abuser was then assigned the credit for 2021, and the survivor was unable to get it. So we'll talk about this a little bit more in the case study, and I'm going to turn it over to Terry next. Thank you.
So before Terry goes, DeMarcus is going to do one of those polling questions. And so the poll will pop up on your screen and you need to answer one or the other. While we're doing that, I want to say that one of the questions that came in was, when the client has missed the 60-day deadline for responding to the math error notice, do you recommend amending the client's return, basically amending the IRS's adjustment to get a new appeal right? So if you've missed the 60-day deadline, remember that the math error, and we'll talk about this a little more in detail, is a summary assessment, which means the tax is already assessed. And so that means that if you've missed the 60 days, they're not going to abate it. You're going to have to go in. I think people have tried different things. One is that they've just gone in and asked for an audit reconsideration. The other is to file an amended 1040, a 1040X, which will be processed manually, which will give you the right to produce evidence. And I think people have had results with either approach. I don't know whether Nancy, you or Terry want to weigh in on that. I do want us to be able to get to the case study.
I'll jump in, and Terry, you can feel free to jump in real quick. I think we're still waiting on answers. So we're at the point where I know Terry's had some cases. I've got some cases where we responded to the math error notice, but we haven't heard yet. But I agree. I think it's worth it to kind of try every option. You know, you could try the audit reconsideration. You could try doing an amended return. I think in a lot of ways, this is new ground, and we're just trying to figure out what's the best way to help survivors, especially in the context of the pandemic and the IRS still being so behind on processing things, processing returns. It's hard to say what's going to get them the quickest response.
I would agree with what Nancy is saying, and that this is such a new process. This point, like we're waiting for responses on our responses to the math error notices.
Okay, Terry, you want to go ahead?
Sure. So if I could have the next slide, please. Okay, so now I'm just going to talk about some of the eligibility requirements for the earned income tax credit. So this credit is based on earned income, as you know, the title states. If you have a qualifying child and you're applying for the earned income tax credit, the qualifying child needs to be under age 19 or under age 24 and in school full time, or if they are permanently and totally disabled, they can be any age. A qualifying child also has to have the appropriate relationship to the taxpayer that's claiming them, meaning that they are a blood relative, they're a legally adopted child, a foster child, or they're related to the taxpayer through marriage, being like a stepchild. The qualifying child also has to have lived with the taxpayer for more than half the year. However, there's no support test, so there's no inquiry into whether or not the qualifying child provided more than half of their own support for the year. For 2021, the amount of the credit has increased quite a bit. The maximum amount of the credit that a taxpayer would be able to be eligible for is $6,728, and that's based on 3 qualifying children. If you don't have any qualifying children, the maximum amount of the credit has gone up again to $1,502, and that's the max for 2021. If a taxpayer does not have a qualifying child, they generally need to be at least age 19. There are some special considerations for those who were in the foster care system or experiencing homelessness. They can be age 18 if they do not have if they don't have a qualifying child. They have to be at least 18 to claim the credit. May I have the next slide, please? So these eligibility rules are pretty much they're the same points from the other slide, but something to note is that if you do have a qualifying child, you want to make sure that that qualifying child has a valid social security number that was issued before the due date of the tax return. And also that, you know, if you're the one applying for the credit or claiming it on your return, that your social, you also have a valid social that was issued before the due date of the tax return. If a taxpayer was filing a joint return, then both spouses would need to have a valid social issued before the due date of the tax return. Next slide, please. So for 2021, there's another special rule for the EITC in that this year, a taxpayer that's filing as married filing separately can be eligible to claim the credit, which is great for survivors that if they have fled, if they're still legally married, perhaps they don't meet the eligibility requirements to file head of household. Then married filing separately might be if it's their only option. Then this credit being available to someone who's using this filing status is a great benefit for this tax year. So in order to be eligible, if you're using the married filing separately status, the taxpayer must have a qualifying child living with them for at least half the year, and they have to either be legally separated from their spouse under some sort of separation agreement, or they can't have lived with their spouse for at least the last 6 months of the tax year. May I have the next slide? Okay. So this is a rundown of the eligibility requirements for the head of household filing status. In order to claim this status, you would need to establish that one, you were either unmarried or considered unmarried on the last day of the year. And being considered unmarried, meaning that you have lived apart for at least the 6 months, last 6 months of the year, or you are legally separated under a separation agreement or decree. So you need to establish that. You also need to establish that you paid for more than 1/2 of the expenses in keeping up a home. And those expenses could include things like rent, utilities, foods, and other household expenses. And of course, you would also need to have a qualifying child or relative living with you for over half the year in order to file as head of household. So for some survivors, depending on how long they've been separated, the amount of money they're paying to upkeep the home, that may be another option for them, especially if they also have a dependent living with them. This may be another filing status option for survivors. May I have the next slide, please? Now we're going to talk about the eligibility requirements for the Child and Dependent Care Credit. In order to claim this credit, the taxpayer must have lived in the United States for more than half of 2021. They must have been paying someone to care for their child or dependent in order for them to work or look for work. The dependent must be under the age of 13, the child must be under the age of 13. And they have to be able to be claimed on as a dependent on the taxpayer's tax return. There is an option to claim your spouse if they were not able to care for themselves, or any other dependent that might not have been able to care for themselves in the taxable year. But note that the child or dependent must have a valid Social Security number or an ITIN by the time the tax return is filed. Thanks. So you can count some work-related payments that you make to other relatives, even if they live in your house, but basically you can't count like another child, like an older child that's babysitting a sibling, your spouse, to be as qualified caretakers for purposes of the credit. So please keep note of that. And also you must also provide the caretaker's Social Security number or their employer identification number if they have a registered business when you're filing your tax return and you're using the form 2441.
So Terry, let's go over, since there's some questions in the chat about the special provision for 2021 about using married filing separate status for the EITC. You want to repeat that again, because people are familiar with you have to be head of household or single to get the EITC, but Congress changed that rule for tax year 2021. You want to repeat that?
Yes. So for 2021, like I said, taxpayers are eligible to claim the EITC if they're filing as married filing separately, but they must have a dependent living with them for at least half the year. So, wouldn't be available to a childless taxpayer. You would have to have a dependent living with you for at least half the year, and you must be either considered unmarried, meaning that you lived apart from your spouse for at least the last 6 months of the year, or you're legally separated under some sort of separation agreement or decree.
So that could mean that you did not have to live apart from your spouse the last 6 months of the year, but you could get a separation agreement in December and still be able to be married filing separately and claim the EITC. And this has been something that as a taxpayer advocate, I made several legislative recommendations about changing this to reflect separation agreements, and even tried to work in getting that into regulations, but we were unsuccessful in doing that. So let's launch another poll while I kind of set up the case study. So you have to answer this in order to be able to get your CLE credit. So we do have a question in about, does legal separation have to be entitled as such? Texas has no such thing. So there is a regulation about what legal separation means in the context of being being considered not married. That's a really complex issue. I think that it says a separation document. So I think if you have a protective order or some other kind of temporary order that means that the person has to be separated, I would take a stab at that. I think because it's a one-year provision, there hasn't been a lot of guidance out, and I think we'll all take that away to see whether we can get an FAQ at least clarifying that a protective order or temporary order could constitute evidence of some kind of written document. Someone else asked that there's basically for the EITC, you have to have an SSN, and it has to be one that is authorized for work. That is correct. So now, as I track all these questions, I'm going to first let us set up. It looks like we have, DeMarcus, do we have enough questions answered that we can take the poll down?
Yep, I'll do that, Nina.
Okay, so let's go to the next slide as well. Terry's just going to give you a little background about the various notices that show that people should have gotten, which kind of sets up the case study. Terry, you want to go through those two slides?
Yes, thanks, Nina. So this first slide here is about the IRS letter 6419. This letter was sent out to taxpayers in January of 2022. And what it did was it reported the total amount of money paid to the taxpayer in 2021 for the advanced child tax credit. And it also lists the amount of children that were accounted for in order to compute the credit. The taxpayer should then use this letter, provided it's correct, to then claim the remaining balance of the child tax credit that is due to them on their 2021 tax return. So for the majority of taxpayers, the advance payments listed on this letter should match up to what they actually received in their bank accounts. We are advising people, to not rely just on the child tax credit update portal or or your tax transcripts. Make sure to check your bank accounts to if you had set up for direct deposit, that the amounts that you see on the letter are the actual amounts that you actually received in hand. So if there's a difference, between the 6419 letter, your online account, and the taxpayer's own banking records, I would say go with what your bank statements say, and report what you actually received. And if you have to dispute that, you might have to show like your bank statements to show that there was no deposit of whatever payment that was reported in error to the taxpayer. May I have the next slide, please? Another letter of note, the letter 1444 was sent out again in January of this year, and this reported the total amount of the third economic impact payment that the taxpayer would have received in 2021. So this letter only accounted for the third payment. If that letter is not accurate, then the taxpayer would then claim what the amount of the recovery rebate credit that they're missing on their 2021 tax return. And again, if there's differences in the letter versus an online account versus the taxpayer's own banking records, the taxpayer should report what they actually received in hand.
And I will mention, I just got my letter yesterday. So even though they were supposed to go out in January, it's quite possible that they may not have been received just yet. And it was dated in March. So there could be letters going out still.
So Nancy, when you got your letter, did it show the date of disbursement or was it just the amount?
I think it just gave the amount.
Right. I think that, you could go onto your online account maybe to see the date of disbursement. Now, okay, so let me deal with a few of the questions that have come in, and then we're going to go to the case study that will also be dealing with some of the questions that have come up. The first one that I think is very interesting was a question basically about joint representation and the ethical issues. You know, let's say that you started a representation, the husband comes in, the one spouse comes in, and in the course, and it's a joint return and you're representing them. And then in the course of that, you discover that there may be some domestic violence involved. The return wasn't consensual. Can you continue to represent both? Obviously, they have a conflict, and no, you cannot. Can you represent one of the other? We did a really good program with the American Bar Association Tax Section Standards of Practice Committee, the last meeting in the winter, on this very issue. And I think everyone on the panel agreed that you had to withdraw, that you had gained in the course of that representation information that could be used against one of the parties, or could prejudice your party. And there's no way that you can actually ethically represent one after you've been representing both without, and you can try to get consent, but at some point the conflict is so great that you really can't have a valid consent if their interests are so directly opposed as it would be in a domestic violence situation. That is my assessment of it. Someone else said, going back to the beginning, how would you counsel your your client to file, would you file, head of household or married filing separately if they are still married? And again, I think, that is so fact specific, and you'll see this as we go through the case study, that you really have to analyze all the facts of the case. But keep in mind with our part 2, talking about innocent spouse, where you may be signing on to joint and several liability for whatever, if you're filing a married filing joint return, and particularly where you may not be able, where the power imbalance is so great, you may not know all that your spouse is doing. And therefore, if you sign your client signs a married filing joint return, they may be signing up for a debt later on down the line. So let's just go to the case study, and then we can try to answer some of the questions as they go along. So I'm going to read the facts, and then at various points, what we did was we designed an evolving case study, which often is how these cases appear, like one thing happens and then another does. And as we go through, we're all going to chime in, and Kim will have something to say about, the circumstances and what might happen with a domestic violence survivor, what documentation he or she may have, etc. So here's the facts. During 2020, taxpayer A was married to taxpayer B, and in early February 21, they filed a married filing joint 2020 return, and they claimed 2 children. The IRS paid the 2020 tax refund into an account listed on the return, which is controlled by taxpayer B. The IRS also pays into that bank account the 3rd economic impact payment for taxpayer A and B and their 2 children, because that's the timing of it. They had that account on the most recent tax return, and they paid the 3rd EIP into that account. In May 2021, taxpayer A flees the abusive relationship with her 2 children and goes to a shelter for survivors of domestic violence. She learns from the shelter that she is eligible for the advanced child tax credit for her children who are under 6 years old and living with her. So that's a lot of money that she could get. She attempts to update her bank account information on the IRS CTC update portal. However, because she has not been able to update any of her photo identification, she cannot pass the authentication. And she is also nervous about sharing her location with the IRS, since she's trying to hide from her spouse. For the same reason, she's also she's nervous about just going and filing an address change form with the IRS. Let's go to the next slide, please. So as a result, the advanced child tax credit totaling $3,600, $1,800 for each child, 1/2 of the year, the total amount for each child is going to be paid out through July through December of 2021. That money is paid into the bank account controlled by taxpayer B via the advanced monthly payments, because that's the account on the 2020 tax return. Taxpayer A cannot contact taxpayer B for fear of bodily harm and psychological harm. The shelter tells her she can claim the correct child tax credit when she files her 2021 Form 1040. So let's talk about what might happen. Nancy, I know you've got some points here, but if legal proceedings were going on, that even though she had managed to get representation, she's trying to get into court, maybe there's, she's trying to do custody, something like that. Do you want to take a stab at that?
Sure. I think a lot of times, well, a good number of the taxpayers that we see in this situation are going through some sort of divorce proceeding or separation or getting some sort of custody agreement in place. So we usually advise them that if it is possible to work it out through the course of their divorce, then they should try to do so. We do see a hesitancy, I think, especially working with maybe some of the legal aids and local attorneys to even address taxes in a lot of these documents. And Kim's shaking her head, yes. So I guess it's not just a local problem here, but it is important for them to try that way, because when we're working with the IRS, there's no guarantee that they're going to get the payment. So I think any way that they can try to get that money, they should, legally, they should legally do so.
Okay, so let's go to February 22, as the plot thickens, taxpayer A attempts to e-file her Form 2021, her 2021 Form 1040. And there, because she separated in May and she's got the children and they've lived with her for more than half the year and she's been separated from her spouse for the last 6 months of the year, she claims head of household status, she claims the EITC and the third EIP for herself and her children because that went into the spouse's account, and the child tax credit for her children. Unfortunately, taxpayer B has already e-filed his return listing taxpayer A on the return using married filing joint status and claiming both children for the remainder of the CTC and the EITC. So he wants to get the second half of the CTC and he's claiming the EITC. So the IRS, because of its rule, it only allows one e-filed return under a taxpayer social, and this taxpayer's the taxpayer A has been claimed on this return. The IRS rejects her e-filed return. So what should taxpayer A do? Anybody want to weigh in here?
Well, so in this case, Nina, I would say the taxpayer should then paper file her return, claiming all the credits that she is eligible for, and claim the children as she is eligible to do so. She'd want to mail that return to the IRS. If she had, with any supporting documents she may have to back up her claims on her return, and also send it certified to the IRS. And she should also want to include the certified tracking number on the top of her return, maybe on the top left, right above the form number.
So let's just, what if taxpayer B had claimed the children and claimed the CTC and the EITC on the return, claimed head of household status, but had not claimed taxpayer A on the return? What would happen there? That the return would still be, taxpayer A's e-filed return where she's claiming the children would still be rejected. But what would you think about then? Would those facts change anything?
Well, sorry, Nancy, go ahead.
Go ahead, Terry.
I was going to say, I guess depending on her need for her refund, we talked about perhaps her just going ahead and e-filing without her dependents, and then going back and still trying to paper file before the return deadline, claiming all her dependents again, and sending that in paper again with supporting documents. I think we had questions about supporting documents, and that would include things that would documents that would speak to each prong of the eligibility requirements for the credit. So like if the survivor had birth certificates with her to establish that she is the mother of the children, residency documentation. So perhaps if if they are in shelter, discuss perhaps documentation from the shelter stating that's where they live.
And Terry, you've also added things like protective orders and,
Yeah.
and things like that too, just to basically show, hey, IRS, there's no way they were living together because,
Mhm.
you know, this was the situation.
I
Yes.
would caution that, and we're going to discuss, you know, what would be supporting documents later. And I know Kim will want to weigh in on this too, what works, what doesn't, but, you know, some things that might be unique to domestic violence survivors. But attaching a lot of paperwork to a return is not necessarily going to mean that the IRS looks at it when they process your return. They're just going to get it into your system, into the system, so it can be looked at down the line, rejected. And we're going to see this evolve. We're going to see how this evolves with this study.
And Nina, I will add with that paper return that they're filing after they do the e-filed return without the children because they, you know, can't claim it, it's being rejected. That paper return that they're filing after they electronically file by themselves is going to be a superseding return. So they do need to label the paper return across the top, superseding return, acknowledging that they did previously file a return, but that second return is really the one and true return for the taxpayer. And that return does need to be filed by the filing deadline for the tax returns, not including extensions.
So let us go to the next slide, please. Okay. So here we go. Taxpayer A files her head of household return on paper, certified mail, return receipt requested. You know, now the IRS receives the paper filed head of household return. She files it before April 17th, which is the due date. IRS issues, I think it's actually April 18th is the due date, but for this year, IRS issues a math error notice disallowing all of the economic impact payment and part of the child tax credit claim on the basis that she has already received 1/2 of the $3,600 paid in advance. And note that there is a requirement actually that the IRS, when it's sending notices to spouses that were listed on a married filing joint return, that they receive, say, send out 2 notices, one to each spouse on that listed on that return. But because taxpayer A did not update her address, was concerned about updating her address with the IRS, she never received those notices. They went to the former spouse's address, this address on the IRS 2020 return, joint return. Okay, so so the IRS issues a math error notice, and you know, the math error notice, which is a CP11 or CP12 or CP13, gives her 60 days to ask the IRS to abate the assessment and follow deficiency procedures, basically audit procedures, where then she will get a notice of deficiency. So what should the taxpayer do? And I think the next slide talks about math error procedures. Is that correct? Yes. Okay. Who wants to talk through that? Nancy, you want to take a stab at it?
Sure. So the IRS is permitted under 6213B to make changes to the return under math error authority without using deficiency procedures. And then it issues, you know, one of those aforementioned notices to the taxpayer, alerting them to the fact that they made the changes, and the taxpayer has 60 days to disagree, essentially. So what we would recommend is that the taxpayer both respond by telephone and by paper form to disagree with the changes made to their return. And we are saying both because of the delays with processing. We want to make sure that it gets on the record with the IRS. So try to get in through telephone if you can, but definitely send a letter, send it certified, make sure you hang on to the tracking. Put your tracking number on your cover letter so that that can be associated with the tracking information, and inform the IRS that you disagree with their assessment. You can go further and make your argument as well. However, the IRS is only requiring at a minimum that you alert them to the fact that you're disagreeing.
Great. So let's go to the next slide, please. Now let's talk. I know there's been lots of questions about documenting eligibility for the credits. So remember, you don't have to supply that documentation when you're calling or writing and saying, I disagree, I want you to abate the summary assessment. but at some point you're going to have to provide the IRS documentation. Now, when I was the National Taxpayer Advocate, I issued an interim guidance memorandum to my employees for advocating in EITC cases for how you could prove relationship, residency, and support. And that interim guidance memorandum is actually public. We've got the link here, and it has a chart in attachment 1 that supplies all sorts of suggestions about the kinds of documents that you could use to establish relationship, that the child has the right relationship with you, residency, that the child, resides with you, and also if there's a support requirement, then, there's also documentation for that if it's a qualifying relative, for example. So I really encourage you to look at those documents. It's a 2-page list, but it's not an exclusive list, but it might give you an idea for how to think about those things. But then also in the context of domestic violence survivors, you may think about these things. Kim had suggested, getting the shelter where she's staying or the local program that has been providing support to the survivor to be able to say, to submit an advocate affidavit that would actually, which is accepted by TANF. So one would think the IRS would accept it, but we may have to educate them. And that certainly might have some impact. You can get affidavits from school counselors if the children's have sought or been referred for help. If the children have gone to a school counselor and have talked about domestic violence and how they've escaped their father or their mother and they're living somewhere. And then affidavits from the HR, folks at the survivor's employer. There could be insurance claims if the abuser damages property. All of these things. And I think, Kim, why don't you talk a little bit about protective orders?
Yeah, I just want to note that I think that a lot of times we want to go to something like just provide a protective order. If you're a victim of domestic violence, surely you got a protective order. And we know a lot of survivors don't get protective orders or even police reports. There's a lot of domestic violence that goes on that law enforcement is never involved in, whether it be individual incidences or throughout the lifetime of a relationship. Somebody could be being brutalized or all these things happening, and law enforcement is never called. So it is not unlikely that there will be no legal trail for this domestic violence, as well as no protective orders. And I think I mentioned in our prep for this is that we often see in many states have a lethality review committee, and we'll go through when survivors have died due to domestic violence, that there is a history of a protection order oftentimes. And so it's just important to note that we have learned along the way that a protective order is not necessarily is what going to keep survivors safe. So just a note about that.
Okay.
And certainly if there is a criminal history, if there's court dockets and things like that, definitely want to pull this forward. But I just am cautioning folks to assume that if domestic violence exists, then there must be a legal trail, and that is not always the case. It's often not the case.
So let's launch the last poll while I try to answer a few more questions, then we can go to the next slide. Someone asked, should you file an identity theft affidavit with the IRS? The IRS has a process where you can say, I've been a victim of identity theft. Now, we've had a lot of conversation about this, whether the IRS recognizes identity theft by a spouse. I think that depends on the scenario. If it's an invalid return, and this was in the context of the spouse, basically married filing joint, and we'll cover this in the next slide, married filing joint, where the taxpayer A hadn't consented to that. The IRS by law would say that that is an invalid return, and therefore it's not really identity theft. You're going to abate, zero out that return because it's not a valid return. Now, someone asked about how long the process takes if you're filing with a math error process. Someone else had posted earlier that I think that they filed something, they challenged a math error or something in October of last year, and it took until February this year to get it straightened out. Right now, all of these things that we're talking about are very, very lengthy. So even if you're filing an amended return or a refund return, you're going to have to figure, if the IRS does not respond to it, then you can wait six months and then file a refund claim in federal district court. Someone else pointed that out. Let's go to the next slide.
And Nina, I'll just add, I think that's a situation where you want to be really clear with the taxpayer that this could be a months-long process, especially if they're hoping they're going to get the refund quick and, you know, better their situation. Unfortunately, we know that this could be a lengthy process. So I think managing expectations there is going to be important.
I'm going to weigh in too, but I'm going to piggyback on Nancy's comment there, is that you have done a fantastic job of outlining how already complex this is. It is unlikely that you're going to work with a survivor that's going to leave their partner, move to shelter, be there for 6 months, and then move out on their own. There's going to be a tremendous amount of back and forth, don't know where to go. So do not be surprised if the folks that you work with return multiple times. It is not going to be a direct line. And that's for many reasons. She didn't have the finances to be on her own. There's no housing available. So just because she may have returned a couple of times and then venturing out again does not mean that this is still not all real and valid and that she's still not living in fear.
Yes. So just as she's done the math there, and I have to tell you that this case scenario is based on a real one that we've done a little bit of adding to, but not much. Before the IRS responds to her math error documentation saying these children are mine, the IRS sends her letter 31C informing her that they already have a married filing joint return on file with her, so they will not be processing her head of household return. So she goes ahead and submits documents and sworn statements following what was suggested in IRM 21.6.1.5.7, which is the process by which you are trying to show that that married filing joint return that was e-filed by her spouse is not valid and is either forged, fraudulent, or signed under duress. So let's go. This is the provision for establishing a joint election and, invalid joint election. And you have to show that you filed a separate return. You submit a sworn statement saying the joint return wasn't valid, maybe because it was signed under duress. Duress is a legal term. You have to show that you are unable to resist demands to sign the return, and you would not have signed it except for force or other pressure. This is where all of the things that Kim talked about, the kinds of violence, the kinds of pressure. It doesn't have to be violence. It can be other forms of pressure come into play. If you didn't sign the return yourself, but it was sent in under your signature, then you do a signed sworn statement saying the tax return was forged. Maybe it might be accompanied by a document, a legal document that reflects your true signature, such as a driver's license or something like that. And then you may even have to say in some instances that you were not legally married at the time the joint return was filed. And that might actually be a case of identity theft. If the taxpayer can establish that it was not a valid return, the IRS will remove that joint return from its system and process the taxpayer's separate return. Okay, so let's go to the next slide. And now this is just the discussion of signing a return under duress. The claimant has to show that they can't resist their spouse's demands and they would not have signed but for such constraint on their will. And here are basically some signs that you might be able, some indications that you might be able to show. This is, of course, issues of documentation. Again, anything, statements from advocates, even statements from family members, when if you're free of that abuse, to be able to get that. This is very, very difficult. And we've cited a blog that sort of talks about this issue so that you can get more background on that. Someone mentioned that, many forged signatures aren't actually signatures because the returns are filed electronically. That is actually that is a case, but if you could say, I lived separate and apart from my spouse at the time that return was filed, that might be, and it was e-filed, that might be evidence that, you did not have communication with your spouse and therefore that return was filed under your signature falsely.
And I think the IRS will probably also look at tacit consent. So if the history is in your taxpayer's favor, where maybe they're always filing separately, you could point to that. But if they usually file jointly, then I think that's going to be a battle to show the IRS that there was no tacit consent.
Right. So let's go to the next slide. Now we're going to IRS does not accept this documentation or process it. It could be either one, it's so far behind. So the taxpayer has sent in this documentation showing that the married filing joint return is invalid. Then when the IRS comes back, it's sort of looking at the head of household and it says, well, okay, even though we haven't gotten your documentation, but you've already talked to us, we're telling you that we received the head of household return after the April 18th deadline. So the taxpayer cannot change her filing status from married filing joint to a non-married filing joint status. And the IRS claims this despite the fact that the taxpayer has timely mailed, has got certified mail receipt showing that it was timely mailed. So at that point, the IRS issues a notice of deficiency. So what should the taxpayer do at this point? Terry, you want to talk about that?
Yeah, so if the taxpayer, if the notice of deficiency is issued, then the taxpayer is going to want to respond to that, stating that the return was timely filed. Maybe if you have documentation of the certified tracking, which is why it's important to have that information attached to the return. Also, if the taxpayer is going to go ahead and file superseding return, excuse me, you're going to make sure that it is that just to know that return will become the original return for the taxpayer. If it's processed, the superseding return will result in both the taxpayer's accounts being adjusted, the one that had the married filing joint, the taxpayer that filed the the invalid joint return, their account will be adjusted, and the taxpayer who is filing the superseding return, their account will be adjusted as well to reflect their proper return.
So I think, we're getting some questions in. I have a client who is a domestic violence survivor, and her estranged husband claimed her child from a previous relationship, along with their 2 children, on his tax return. Would the same process follow, as it appears for many of the tax credits a stepchild may qualify? And the answer is absolutely yes. That's correct. Someone else commented, I found that correspondence exams often will not accept any documents aside from school records, medical records, perhaps public benefit records. Even when the children were listed on the taxpayer's lease, exam has said that this does not show where the children live, and exam says affidavits are not evidence. Polly, this brings up a really important issue that I know I personally have fought with the IRS for years about. In tax court, which will obviously be the next step for this taxpayer, or in district court, affidavits would be accepted when you're meeting with appeals or with counsel. And in fact, in 2003 and 2004, the IRS, working with Treasury and the National Taxpayer Advocate, MOA, worked on a test of an affidavit form that was very, very simple, and that taxpayers could get people who had either official records knowledge or personal knowledge of where the children resided for periods of time could fill out, signing under penalties of perjury. And that research study showed that that form was more accurate than any other forms or documents or even simple affidavits or statements on letterheads that the IRS was currently accepting. I think this is I really have argued that the IRS should be using that form. I've posted that form elsewhere, and I think it's in our materials, but if not, they'll be in our updated materials. And it's still out there, and I would suggest using that form as a template, submitting it, and then fighting it in appeals and even in tax court that you have submitted that documentation. Which really leads us then to the next slide, which is, that the IRS issues a notice of deficiency. And so what should the taxpayer advocate do in that case? They have 90 days to petition the tax court. Nancy, do you want to talk about that?
Sure. And this example comes from cases that we've had where we're hearing from the taxpayer that there actually was pressure even from the judge for them to go ahead and file married filing jointly. So I think first and foremost, you want to remind the taxpayer they are not required to file married filing jointly, even if they're married. They can choose to file separately, and really in a situation where, they've fleeing from the abuser, maybe they didn't live together for the year, it would probably be the smarter choice for them to file separately from their spouse. If they did go ahead and file married filing jointly and maybe are regretting it after the fact, it's possible perhaps that they would be eligible for a superseding return if it is prior to the return filing deadline. You would want to caution them, though, that if doing so violates an agreement that they have with the spouse or former spouse, they need to carefully consider that, because they could be opening themselves up to liability if they're not following the agreement. If they are stuck with that married filing jointly return, then it's possible they may be poised for an innocent spouse claim down the line. So they would want to make sure that the IRS is updated with their address and current information. And I just want to remind everyone, the IRS is supposed to keep all identifying information confidential and private. And that victim of domestic violence indicator is just another reminder for the IRS, especially in those cases, to be extra careful that they're not sharing anything, including the name. So, we've had clients that have gone through a name change, and the IRS is not supposed to be sharing that information either. So they are supposed to be protecting all of that.
So one little wrinkle, if the taxpayer were to go to tax court, if they get a notice of deficiency, and of course that is the notice that says you have 90 days to petition the tax court, we're proposing a change. And so you've got 90 days to go to tax court. That's different from math error, which has already made the change, and you have 60 days to ask the IRS to reverse that change. And then once you ask the IRS to abate that change, and it still says, we think you don't owe, you think you're not entitled to this EIP or the child tax credit, or we're not, et cetera, then you will be issued a notice of deficiency, which will give you the right to go to tax court. And when obviously the taxpayer can go and reach out for a low-income taxpayer clinic and free representation from the clinic. But the important thing about tax court, one thing that we've been really trying to think about dealing with these returns, is that the IRS's policy that it is rejecting the taxpayer's A's e-filed return under the Beard test of, US v. Beard. That return is an actual return, a tax return, and it is just the IRS's electronic filing system that has said we're not going to accept it. And we've been looking for opportunities to make that argument in tax court, where it may actually matter where the taxpayer tried to e-file that original return, might have some significance in terms of the date of filing and things like that, where the paper return might be filed later. And so I just want to flag that just because the IRS rejected that e-filed return doesn't mean it isn't a valid return. Whether there's any legal significance to that depends on the facts of the case. I think we've really covered a lot of information. I want to go back through the questions before we sign off to just make sure I haven't missed anything of significant importance. I also want to note that coming up will be April 21st, the part 2, which will deal with innocent spouse claims of this series. The ABA will be posting this video, and the Center for Taxpayer Rights will be linking to that. And we will also have the materials for the video as well. So I thank you for that. And I think we've come at the time. You will be getting a message, and when will part 2 be available for registration? People will be notified with this. Maybe we will be able to send out to you all that attended and signed up for this one, that the registration is open for part 2. So thank you for attending. Thank you to my wonderful panelists. You all have been terrific in a really challenging situation. You will be getting certificates of attendance by email. They will be coming to you. Thank you all.